The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. Ms. Baldwin, you may proceed.
Good morning, Your Honors. May it please the court. The district court abused its discretion by imposing the bans on internet access and adult pornography in this case. Its generalized concern that these items were problematic was insufficient to justify the severe and expansive restrictions they imposed. The government relies on unsubstantiated allegations from the revocation petition to defend the bans. However, the district court explicitly disclaimed reliance on those allegations when imposing conditions. At the hearing in Joint Appendix 110 to 111, you can see the district court told the government, if you want me to consider the allegations in the revocation petitions the defendant hasn't admitted, put up evidence or I'm not going to do it. The government didn't do it, so they weren't considered.
Ms. Baldwin, this is Judge Floyd. You started out your argument by saying it abused its discretion. What about the pornography ban? Is that going to be, the standard review going to be plain error or abuse of discretion?
It should be abuse of discretion. The defense counsel objected to the pornography ban in the district court, arguing it wasn't reasonably related or overbroad, and overbroad.
Okay.
So to the extent the plain error question goes to the government's arguments that even objected to conditions at revocation hearings are reviewed under a plainly unreasonable standard, which incorporates plain error elements, that is incorrect. As I noted in my brief, every single court of appeals reviews the objected to conditions at a revocation hearing for abuse of discretion. And the reason for that can be seen in the Crudup case, where the revocation imprisonment term is governed by 3742 subsection regarding a sentence that was imposed without an applicable guideline. And so, but when it comes to conditions, these condition challenges, the subsection under 3742 is that the sentence was imposed in violation of law, because that's what these challenges are about. They're saying these conditions were imposed in violation of 18 U.S.C. 3583D. And here, the most severe condition in the case is the internet ban. And that condition doesn't satisfy 3583D because it exacts a greater deprivation of liberty than reasonably.
Ms. Baldwin, before you get to the substance, I want to spend a little more time on the standard of review. So your position is that the special conditions of a revocation sentence fall under 347-2A1. Is that what I'm understanding you to say?
Yes, Your Honor. And
so is it your position that you would have a different, does that imply that the prison sentence and the special conditions are not unitary? Does that run afoul of the unitary doctrine?
It's not that they're not unitary, but they're just the particular issues being appealed are different, and so they garner a different level of review. If a district court imposed a sentence in excess of the statutory maximum, there's no, like, even if there wasn't a guideline, you wouldn't look for plainly unreasonable. You'd say, like, that was imposed in violation of law. So regardless of whether or not there's settled Supreme Court or Fourth Circuit precedent, that's just not, that's an error of law that should be corrected on appeal.
Okay. Is there a or after 1 and before 2 in the statute?
I don't believe so, but I don't have a copy of it in front of me.
There's an or after 2 and after 3. What's the significance of there not being an or after 1? Does it mean 1 and 2 both have to be met if you're looking at 1?
No, I would say not. I mean, because, well, part of the problem, I mean, we have had sentencing appeals for many a time, and I've never seen a district court indicate that a sentence had to be both had to violate settled Supreme Court and Fourth Circuit precedent and be opposed in violation of the law when there was objection in the district court. So
yeah, it's just odd. It may be, I don't know what that means. It may be an error. It doesn't say and either. It's just peculiar that it doesn't have the or there. But anyway, go ahead. I appreciate your answer.
I understand. Thank you, Your Honor. So going back to returning to the internet ban here, and it's a greater deprivation of liberty than reasonably necessary. And that's because of 3 reasons with the internet ban. First, an internet ban restricts an immense amount of content that's wholly unrelated to any recidivism risk. So as the Supreme Court noted in Packingham versus North Carolina, the need to protect children from sexual predators is indeed compelling. The problem is preventing them from shopping on Amazon, reading the Washington Post website, or checking symptoms on WebMD simply doesn't have anything to do and doesn't move the ball on that goal at all. And the second reason is that an internet ban fails to consider the adverse consequences its restriction has on rehabilitation, which is the point of supervised release. Internet is an essential part of our modern society. Taking it away is going to make it extremely difficult for a defendant to re-enter society. And you need look no further than the pandemic we're going through right now, where internet access is what's allowing us to even continue our jobs with complying with social distancing, going to doctor's offices without risking exposure, ordering groceries online. And then the third reason is that there are lesser alternatives available to the district courts aside from outright bans. It includes filtering software to block certain contents or categories of activities. It includes monitoring software. It also includes other conditions that are imposed on Mr. Ellis. So for example, a polygraph requirement, which Mr. Ellis has. And in fact, Mr. Ellis's polygraph condition was what allowed the district court to determine he did access a device that wasn't being monitored by the probation officer. So these conditions show that they do work. The probation officer is still able to monitor the internet activity and ensure it's not being used improperly. And of course, if there is a violation of these conditions, the district court can revoke and send them back to prison, which is what happened here, where Mr. Ellis has served 30 months on revocations, all of which were non-criminal technical violations. He has served more than 2 times what he got in his original federal offense that carried the supervised release term.
Ms. Baldwin, let me ask you, I take it in light of your argument in the last minute or so, you're not asking us to adopt a bright line rule that an internet ban will always contravene 3583D, are you?
No, I'm not. I would say, based on the majority of the court's appeals is is a general prohibition. They say generally an internet ban for non-contact offenders is going to exact a greater deprivation of liberty because of those three factors. Of course, if you have the unusual case where there's something like really serious that would justify a ban, that's still open to the district court. But generally, it's going to require a substantial justification, far more than just saying he has a sex offense and has violated his conditions in the past. And here, the deprivation is even more unreasonable because there's nothing in the record indicating a computer or internet was ever used in any of Mr. Ellis's crimes. His child pornography offense, which occurred in 2005, and his failure to register. So, 4 courts of appeals have noted that where the record lacks evidence of using the internet to facilitate a crime, there's no reasonable relationship. It can't be to the generalized point of, well, these both involve sexual activity or select. So now I would like to move on to the pornography ban. And first is the scope of the pornography ban here is overbroad. It's a greater deprivation of liberty than reasonably necessary, both because of what pornography encompasses, as well as the location restriction that prohibits him from going anywhere where he could obtain these materials. So I believe, as this circuit noted in an unpublished decision in Warbleski that had a similar condition, it could very well prohibit a defendant from even going to a home with an HBO subscription, because visual depictions of simulated sexual, yes.
Ms. Baldwin, sorry to interrupt that, and I'll let you get back to that quickly, but am I correct that you have abandoned your argument that as to the vagueness of pornography, and your argument relates to the overbreadth of it?
I have. So my argument is, if the court adopts the narrowing construction proposed by the government of tying it to the criminal code, then the court doesn't need to reach vagueness of undefined pornography.
Okay, thank you.
So visual depictions of simulated sexual activity between adults are frequently in magazines, advertisements, R-rated movies. So not only does this condition prohibit Mr. Ellis from watching Oscar-winning movies like American Beauty or HBO shows like The Wire, it prohibits him from going to Target and libraries because such materials can be obtained. And the district court here didn't justify why viewing legal adult pornography increased Mr. Ellis's recidivism risk, which is a necessary component to crafting a condition that is related to that recidivism risk and narrowly tailored to address it.
Ms. Baldwin, doesn't it in effect prohibit him from going any place there is a phone, a computer, or cable, maybe not even cable TV, but a TV that has cable access?
Yes, I would agree with the latter. The only issue I think possibly with a phone is if it's a landline, the 2256 is
I meant a smartphone.
But yes, that's correct, Your Honor. So it is extraordinarily overbroad, and the Ninth Circuit has weighed in on a similar one and just found, preventing someone from going to a big box retailer is just more deprivation than reasonably necessary. And that is especially true here, where there's nothing in the record indicating that viewing adult pornography is a recidivism risk for Mr. Ellis. So although there is information in the record regarding his viewing adult pornography, there is nothing from a treatment provider indicating he requires treatment or it's affecting his rehabilitation. In fact, Mr. Ellis was already subject to a condition, sex offender condition number 2, that required him to abide by recommendations of a treatment provider. The fact that probation
Ms. Baldwin, let me ask you this. Assume we rule in your favor. How would we craft an opinion that would give the district court some guidance upon the resentencing issue? What should we tell the district court?
Sure. You should tell the district court to, excuse me, to, when you're evaluating a condition under 3583D, you should identify a particular recidivism risk and then, explain. So in this case, if the district court were to say, I find Mr. Ellis viewing, pornography that's on the sites of of Pornhub, then he can craft a condition restricting that activity and then explain, well, the porno, because, so it's hard because honestly, there needs to be more factual development. There's simply not enough in a record. I mean, the district court's explanation here at JA 118 to 119 is that these items could be problematic, and that's true, but there's just so many ways in which they could be problematic. I'm not entirely sure what the district court's issue with Mr. Ellis viewing pornography was. I mean, at the time it was requested, he had a job, he had housing, the treatment provider didn't recommend any restriction. So there has to be more of an evaluation of the relationship between the thing that the district court wants to restrict and the 3583D factors that are centered on making sure this guy doesn't recidivate and increasing his and fostering his rehabilitation into society. There are no further questions. I'll sit down now.
Thank you, Ms. Baldwin.
Thank you.
Mr. Enright?
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court acted within its discretion and certainly did not act plainly unreasonably by barring Mr. Ellis from the internet and pornography after revoking his supervised release for the third time. The court acknowledged that these conditions are unusually broad and wouldn't be appropriate in virtually any other supervised release revocation case that court had ever seen. But
Mr. Enright, if you could, but I know you want to get to the substance and I want to hear that, but the standard review is something I want to make sure I understand your position on. The government, I mean, the defendant says that their appeal is under A1, not A4. And if it's under A1, it doesn't have the plainly unreasonable language to it. What's your position to that?
I think Crudup resolves that issue, Your Honor. The Crudup held that a revocation sentence is a sentence for which no guideline applies and therefore falls under 3742A4. I think you alluded to this in your questions to my friend. The revocation, the supervised release conditions are part of the sentence upon revocation. And the idea that they are overbroad or that they exceed the court's discretion doesn't make it an illegal sentence. Illegal sentence refers to something like a sentence for which there's no statutory authority at all or for which exceeds the statutory maximum. An argument that it's unreasonable or that it exceeds the discretion given to the court by the statute is pretty much the same argument as under 3553A, that it's greater than reasonably necessary, and that's not considered an illegal sentence. That's considered. Let me
assume I agree with that. Haven't we? I don't think either of y'all cited our recent Van Donk case. I'm not sure if you're familiar with that.
I am familiar with it, Your Honor.
Doesn't that, whether there's not a whole lot of analysis of this issue there, but doesn't that end the question?
I don't think so, Your Honor. The Van Donk decision applied the abuse of discretion standard, but that's consistent with the plainly unreasonable standard because the plainly unreasonable standard has two parts. First, you determine whether the sentence is unreasonable, which is largely an abuse of discretion standard. Only if you decide that it's unreasonable under that part do you move on to the second step, which is to determine that it's plainly unreasonable. Van Donk only reached, and as far as I know, the only issue was litigated, was whether it was an abuse of discretion, that first part of that standard. Certainly Van Donk didn't specifically address whether the standard of review was plainly unreasonable, but I don't think there's anything inconsistent with the view that it's plainly unreasonable in Van Donk. And in any event, I think Crudup would control because Crudup is a binding panel decision. I do want to note that this court, too, in an unpublished decision in Shires, applied the plainly unreasonable standard specifically to conditions, as have other circuits, including the 10th Circuit. It's not in our brief because I didn't see this argument until the reply brief, but I think it's United States versus White, 244, Fed 3rd, 1199, and Shires is 199, Fed Appendix 295. That's applying the plainly unreasonable standard specifically to conditions. And I think
do I understand your position is that an opinion that applies abuse of discretion to revocation conditions is not inconsistent with a standard that reviews those for being plainly unreasonable?
No, Your Honor.
Understand.
I'm sorry if I'm being unclear, Your Honor. In Crudup, this court described the plainly unreasonable standard as containing two parts. The first part is that the court looks at whether the sentence is unreasonable. And the reasonableness standard, the Supreme Court has said, is an abuse of discretion standard. Only if it determines that the sentence is unreasonable does it then move on to the second step, which is to determine whether it's plainly unreasonable under the definition of plain from the plain error review standard. So what I think Van Donk did was evaluate that first component. Is the sentence an abuse of discretion under the unreasonableness part of the two-part standard? It didn't grapple with, it didn't address, as far as I know, an argument that the plainly unreasonable standard applied, but it didn't need to, because under either standard of review, the first part of the plainly unreasonable standard or abuse of discretion on its own, the result was the same. And Your Honor, I think that answers the same here, because the court did act within its discretion by imposing these conditions. We may have a significant disagreement with the record, Your Honor, because I understand my friend's position to be that there's nothing in the record suggesting that the defendant requires treatment. But in fact, the defendant's position in each of his revocation proceedings was that treatment was critical. The first thing he said in his first revocation petition was he wants to receive treatment, Your Honor. He needs inpatient treatment for his issues, which he described as depression, mental health issues, issues with gender identity that had caused him to face confrontations in his community. He had significant and many issues that required treatment, according to his counsel. In the words of his attorney, he's been afforded but had never completed treatment for the issues he has, and I think that treatment is well needed. The district court agreed. In every single revocation, it emphasized, you need to go to treatment. This is absolutely critical. He possessed and child pornography, which got him in trouble in the first place, and then he violated SORNA, and those stemmed, according to his counsel, from issues that required treatment. And of course, treatment is not a technical thing. It's a core purpose of supervised release. And the defendant simply would not go to treatment. The district court made very clear this wasn't a situation where he couldn't go to treatment. He had an issue with homelessness early in his supervised release term, but he had overcome that. He found a home. He found a job. He simply refused to go over and over again. During his first release term, he missed a host of sessions and failed to show up even for his intake session for sex offender treatment. During his second release term, he lied during a basic evaluation about daily pornography use and the use of internet devices. And during his third release term, he refused even to complete the sex offender treatment intake interview and refused to attend the required mental health sessions. He just said, nope, I'm not going to go. I'll call you when I'm ready, but I'm certainly not going to go twice a month. It was only after that, and only after so many other things have been tried, like monitoring software, like allowing approved devices to access the internet, like prison, and less restrictive limitations on pornography and internet use. It was only after that, and after 3 revocations, that the court said, look, in response to your dogged unwillingness to go to treatment, I am going to take away your internet completely, and I'm going to take away pornography. And if you begin treatment, if you even begin treatment, come back and we can talk about a modification. And that decision was well founded because it was the internet and pornography that was getting him into trouble. He got himself kicked out of the residential reentry center that the probation office went to lengths to get him into, not once but twice. And he told the probation officer that was because he didn't agree with their policies on phone use and that he couldn't live without his phone. He lied during his sex offender treatment about his pornography use. And the probation officer reported in his first revocation petition, which was not disputed at all, the defendant himself relied on it in the district court, that he admitted a serious pornography and sex addiction. And
so, Mr. Enright, if
yes,
I could, I appreciate the lack of compliance. I mean, I think there is support for that, but I still think we have to look at the conditions actually imposed. And,
I agree, Your Honor.
And it seems to me the way the conditions are written, he would not be able to be in his residence or any residence if there's a computer, if there's a smartphone, or if there's a TV or that has cable access, much less a smart TV. Because in any of those situations, it's a place where pornography could be viewed. And it seems to me that the ban on internet would prevent him from working if scheduling or communication is required via the internet. First of all, am I correct in how I read? Am I misreading the effect of the ban? I mean,
so I don't think so, Your Honor. I don't believe there's another condition in his supervised release judgment that is similarly broad with respect to child pornography, and that's very common, and I don't believe has ever been construed to mean that you can't be in a place where the internet is available simply because child pornography is obviously technically accessible via the internet. There are a few doctrines that generally apply to supervised release, and I believe they were detailed in the Van Donk opinion. One is that all supervised release conditions exclude inadvertent violations. So, the idea that he might go to a grocery store or something and they might have porn in the back and he's going to get revoked for that. No, that's not going to happen. It can't. He would have a defense. It was an inadvertent violation.
Mr. Enright, so we'll construe these conditions based on your representation that nobody's going to enforce them? Do you have that authority to do that?
Well, no, Your Honor. I'm not saying nobody will enforce them. I'm saying
that's what you see. Suggest that you have the authority to say that he's going to get a free pass if it's done. And it's nothing about inadvertence or your authority to represent him or to say that you said it was okay. We have to,
Your Honor,
we have to construe what's before us.
Your Honor, absolutely. It's up to the court to construe this term. I'm not suggesting that I'm construing it myself. What I'm saying is that this court's decision in Van Donk said that supervised release conditions are construed to exclude inadvertent violations. At a release hearing,
how would it be inadvertent if he uses the internet deliberately to find a job?
well, that wouldn't be inadvertent, Your Honor. I was responding specifically.
We're going to stop him from getting a job?
No, Your Honor, I believe the
You know
defendant.
how many? I don't know whether or not you've applied for. Maybe, probably not. But you know how many jobs? The only way to apply is through the internet.
I understand, Your Honor. Now, the probation office works with defendants who are subject to these.
I'm asking about the probation office. I'm talking about what the judge said. We're construing what the judge said. You said this is a sentence. So
it is, Your Honor.
It says that you cannot use the internet.
Absolutely, Your Honor.
Show me where there's any exception for finding a job.
Your Honor, there are no exceptions.
And service that's by virtual meeting, any of those things. Tell me that.
Your Honor, there aren't any. I'm not suggesting that there are exceptions to that internet ban.
That's what I thought.
No, Your Honor. And if I came across differently, I apologize. I wasn't purporting to say that. I do believe that the probation office works with the defendant. I think they provide them with a flip phone and other means and make sure that they do have access to jobs that don't require them to use the internet. To be fair, that's not in the record because we don't have in the record, at least before the district court previously, what the court did after this was imposed. But the probation office wants the defendant to succeed, and they're the ones that asked for it. They want him to get a job. They want him to get on track so he's not being constantly revoked. And they're the ones that asked for these conditions. The problem was when he wasn't subject to these restrictions, he wouldn't attend one of the basic tenets. It's the supervised release revocation, to address another thing my friend said, is not just about avoiding recidivism of the same offense. I mean, that's ultimately certainly a need to protect the public from further crimes and to deter him from further crimes are core purposes. But another core purpose is to provide him with rehabilitative and corrective treatment. The court considered that.
Mr. Enright, it looks to me like what the district court was doing, and I'm not inside his mind, but he's, a lot of other options have been tried. They weren't successful. And it looks like he says something to the effect, and I think he references this in the record, that this type of restriction may incent him to go do what I think he should do, which is go get treatment. But it seems to me that's a dangerous sort of rationale for a condition, because that you could do a bunch of stuff that would, in effect, incent him to do what the district court feels is appropriate. And yeah, I mean, I could name some. I don't need to. I mean, we can all use our imagination. It seems to me the district court, I appreciate its frustration given what happened, but maybe using conditions that are, so broad that the guy can't even, get a job. He really can't operate. Yeah, I'm not sure he can live anywhere other than a, residence that's got no technology in it, or visit a place that does, not even a retail establishment. Seems to me the frustration may be understandable, but he went so far that you've restricted the guy's liberty to the point that he can't do anything.
So I suppose there are 2 points I want to respond to. The first being the one about creating incentives. The court didn't just pick random things that the defendant liked and said, I'm going to take them away. These were things that were getting him in trouble. It was his phone use and his need to be on the internet that got him kicked out of a residential reentry center. It was his daily pornography use and his internet use that caused him to make false statements during an evaluation. I think the court was very cognizant of that. It wasn't just a hey, we're going to find something you like and take it away. If there's something that's interfering with your treatment, and you've tried every other thing, and to respond to your second point, I think the court acknowledged and recognized the breadth of these conditions, but during his prior supervised release term, he was subject to a less onerous pornography ban, which was just, you can't possess or view pornography. It didn't restrict locations, and he was subject to a requirement that he obtain approval from his probation officer before using an internet-connected device, and those didn't work. He still told.
But is that the? I mean, I agree. So that I don't think though there's law that says if appropriate conditions aren't effective, that you get to use conditions that over restrict liberty.
It's not that there's ever a circumstance where it can over restrict liberty, but what the standard is, it needs to be no more restrictive than reasonably necessary to further the purpose. And what the court, I think, did was say, I'm going to exercise my discretion to conclude that these are reasonably necessary and are no more restrictive in the light of the extraordinary number of other things we've tried that haven't been successful. So the combination with the threat of revocation, the monitoring software, the requirement of approval, and that wasn't enough. But here we can at least put it on equal footing. So your ability to use your phone isn't what's standing in the way of going to treatment. If you can't use your phone either way, treatment isn't going to affect your phone use, so you might as well go to treatment. Maybe that will incent him to do it. He wants to avoid treatment. I think this is something that my friend's brief points out. A lot of cases, including the Van Donk case, recognize that treatment providers often say, "Don't use pornography." So this makes it so that he doesn't have that incentive to avoid treatment. And I think that's why the court properly exercised its discretion and didn't act plainly unreasonably. I don't have too much time left. I'll answer any questions if the court has them. If the court has none, certainly.
I really want to get you nailed down on this. As to the pornography ban, are we reviewing that for abuse of discretion or plain error?
Your Honor, I believe it's the plainly unreasonable standard, which has components of both. The vagueness issue on the pornography ban, which I understand to have been essentially abandoned, that would be a pure plain error, all four prongs. But the question of whether the pornography ban was reasonably related to the factors, the relevant factors, I see my time is up, Your Honor. May I finish answering Judge Floyd's question?
Yes, you may.
Sure.
Thank you, Your Honor. To the extent it's alleged to be outside the court's discretion or overbroad, that's subject to the plainly unreasonable standard, which first asks, is it an abuse of discretion? Is it plainly unreasonable in the light of the 3553A factors that are made relevant by 3583D? And then the second question is, if the court says yes, is that conclusion plain under the plain error standard of review, under the meaning of the word plain and the plain error standard of review, which is it dictated by settled law in this circuit? I know I'm over time, so if the court has no further questions, I will close and ask the court that this court affirm the decision of the district court.
Thank you, Mr. Enright. Ms. Baldwin, you have some time reserved.
Thank you, Your Honor. So address a couple points. First, on the standard of review, Crudup doesn't control. Crudup didn't say anything about 3742A1 and conditions violating 3583D. So it doesn't control. And a policy reason for you not to go down that road is the Supreme Court has never addressed supervised release conditions. And this court, to the extent it has published opinions on the substantive validity of conditions, I believe there's one. So in essence, the government's saying you are not going to be able to find these conditions unreasonable, especially because at the original sentencing, we all know the participants forget about the conditions of release. All they care about is the imprisonment term. So you should not do the plainly unreasonable standard. Discretion should be applied. So the second issue is regarding the facts with pornography interfering with treatment. That's one of our arguments. There's nothing about the pornography interfering with treatment. There's nothing that he didn't show up to his appointments, which, by the way, he missed appointments in his for his first revocation. Since then, he hasn't missed an appointment. The third revocation involves a revocation where Mr. Ellis merely stating he would go once a week rather than the recommended twice a week. Probation revoked him 13 days after he made the statement. So and on the government's claim, well, we're not going to punish inadvertent violations. Well, that's if he makes a wrong turn and winds up in South Carolina when he didn't get permission to go outside the district. That's not, well, our condition by its terms prohibits you from going to a house with HBO, and you went to a house where you knew he had HBO. The government's acknowledgement that they're not going to enforce it that way is dispositive. That shows it's not narrowly tailored. It violates 3583D, and it needs to be vacated, sent back to the district court to reconsider it. And finally, on the internet ban, the court has tried a lot of things, but it can't be forgotten, Mr. Ellis has not committed a substantive sex offense since 2005. None of his conduct during supervision was criminal conduct. And despite there being 3 revocations, the district court has never specifically enunciated what is problematic about adult pornography and internet access. He allowed the probation officer to decide what internet access he should be given, and now he's just outright banned internet access. So, the district court has tried a lot of things, but the district court has not tried enough where he can just throw his hands up in the air and say, you are banished from the cyber world. We don't banish sex offenders who violate their conditions from the physical realm. We shouldn't do it in the digital realm. And indeed, in Eaglin and Helena, the Second and Third Circuits adhere to the view that the internet bans are a greater deprivation of liberty than reasonably necessary for serial violators. It included an enticement defendant who similarly violated his computer restrictions. The Third Circuit said, you've got to try again. There's not even any evidence in the record about the efficacy of monitoring. Or what about limiting his access to the probation officer's physical office space so he's actually observed? So for these reasons, we ask that you vacate the conditions of release, banning internet access, and adult pornography.
Thank you, counsel. Under the circumstances, in lieu of our normal tradition of coming down to shake your hands, we'll just have to say we appreciate so much your being here. Thank you so much for your arguments, and we hope that you will be safe and stay well. Thank you, counsel.
Thank you, Your Honor. We appreciate it. I appreciate it.
Thank you. Thank you so much. And ask the clerk to, I guess we'll be fine. Thank you. I don't think we need a recess. Kenzie, you ready?
Good morning.
Good morning.
Good morning, Judge Gregory. I'm glad to be with you this morning.
Good to have you here.
Lloyd and Quattlebaum, very nice to see you again. I'm Andrew McKenzie. I represent Reco Bethea. This case involves a conviction against Mr. Bethea, conspiracy to distribute cocaine and crack cocaine. The issue is whether it was an abuse of discretion for the district court judge to reimpose sentence on Bethea without regard to the First Step Act case. Let me say this at the beginning. We filed the original opening brief in this case back in November of 2019, last year. There was very little Fourth Circuit authority on this issue at that time. I acknowledge that during the last 11 months, there have been some cases that have come out that are not exactly favorable to Mr. Bethay's position in this case. I would nevertheless, I would like to take you through the procedural posture of this case, which is a little bit different from the cases that have already been decided, and also point out a couple of aspects to this case that I think the court should at least consider before making its decision.
Mr. McKenzie, I don't address, but I would ask you to please address the motion to dismiss in the course of your argument, so in addition to whatever substantive arguments you have on the issues.
Yes, sir. This case started back in June of 2014 when Mr. Bethay was originally indicted. During the course of the case, there was an 851 enhancement filed by the government based on 3 state court convictions that meant that Mr. Bethay was facing a mandatory life sentence. There was a plea agreement where Bethay agreed to plead to the conspiracy count, agreed that he would have a life sentence, and that he stipulated to the 851 enhancement. He agreed to cooperate. If his cooperation was deemed to be substantial assistance, then the government agreed to withdraw 2 of the 3 851 enhancements, meaning that Bethay would be facing a 20-year mandatory minimum instead of mandatory life. He also agreed to abide by all the conditions of his bond and all laws. And he waived his right to appeal. He waived the right to bring a 2255 motion. There were certain exceptions to that, including ineffective assistance of counsel. The court accepted his plea. The pre-sentence report came out. The sentencing hearing was held August of 2015. At that point, the government refused to withdraw the 2 851 enhancements because it was learned that Mr. Bethay had cooked and or prepared crack cocaine during the course of the case. That was a violation of the plea agreement. He also lost his acceptance points. So at that point, after the sentencing hearing, his guidelines were set at 151 to 188 months, which was approximately 12 to 15 years. That, if I read this correctly, that is the sentence that he would be facing if the First Step Act applied to his case, rather than a life sentence. But of course, the judge, his hands were tied, he had to give him a life sentence. No appeal was filed at that time. In October of 16, Bethay filed a 2255 motion alleging several things, but most importantly that he was denied his right to appeal. He did want to appeal. He wanted his attorney to file an appeal, and he did not do so. The government contested that, and that case was in litigation for some 2.5 years. During the course of that 2255 case, the First Step came out in December of 2018. Under the First Step Act, the 851 enhancements were changed to where now, if they would not be facing a life sentence, he would be facing a mandatory minimum of 25 years. And more importantly, the First Step Act redefined what counts for an 851 enhancement, relabeling it serious drug felony, to where the prior conviction, the defendant would have to have served at least 12 months in jail on the prior conviction for it to count as an 851 enhancement. If they had no such prior convictions, he would not be facing an 851 enhancement under the First Step Act. So the court in the 2255 case issued an order in July of 2019 denying all grounds except the issue regarding the appeal. And Judge Anderson in the district court acknowledged that, if the defendant alleges ineffective assistance of counsel, including the denial of the right to appeal, a hearing is required. Under Fourth Circuit precedent, a hearing must be held. And Judge Anderson did set a hearing for September of 2019. But then it was learned that Mr. Bethay had some serious medical conditions, and it was very expensive to transport him for that hearing. So, and Mr. Bethay refused to do the hearing by video. So at that point, Judge Anderson changed his mind and said, well, there's not going to be a hearing. He simply, by written order, he vacated the prior judgment and sentence and re-entered it, allowing Mr. Bethay to appeal anew. He stayed consideration of all the other claims, whereas before he denied all the other claims, he changed that and stayed consideration of all the other claims. And then the court filed the notice of appeal. So it's our position that at the resentencing, it was abuse of discretion for Judge Anderson not to disregard the First Step Act. Section 401.
Why didn't you, Mr. McKenzie, how did your client not waive that argument? How does the plea agreement and the waiver of either appeal or a collateral attack not apply to the argument? The only exception I saw was an ineffective assistance of counsel claim, and yeah, that's not the basis of your abuse of discretion. So how is your client's position not waived?
There are exceptions to an appeal waiver or a 2255 waiver. Most importantly, one being that if it's an illegal sentence, if the judge exceeds what is allowed by law, under those circumstances, regardless of the appeal waiver, the defendant can still pursue an appeal. And that's essentially what we're alleging here, is that the first...
But that's not, I mean, as I understand this provision of the First Step Act, it's not, it wasn't retroactive. So is this actually a sentence that violated the law? It seems to me it's more of a change in law type circumstances, which we've held, I think, are not the type of things that allow someone to avoid a waiver.
What we're saying is after the First Step Act was enacted, Judge Anderson vacated the sentence and then resentenced Bethay. So we're saying at that point, the First Step Act should apply because it's after the date of the enactment of the sentence. And also there was supposed to be this hearing that never took place. On the 2255 motion, there was supposed to be a hearing about the ineffective assistance of counsel involving the lack of an appeal. Now that hearing didn't happen, but if it had happened, I suspect that Judge Anderson would have ruled the same way he did. And when he did that, well, then the First Step Act issue presents. That is the first, it could have been argued that, well, now you have got to apply the First Step Act. And I think that's an argument that should have been made. But Bethay never had the chance to do that because Judge Anderson canceled the hearing.
How do you deal with the argument that the First Step, that the particular provision of the First Step Act here applies if a sentence for the offense has not been imposed as of the date of enactment, and the government says a sentence has been imposed? It admittedly was vacated, but a sentence was imposed. So how does the text of the statute not, prevent the applicability of the relief you seek under the First Step Act?
Well, I don't think that necessarily forecloses this argument. It doesn't say any sentence. I mean, it doesn't say an original sentence or an initial sentence or any sentence. It says a sentence. So I think that leaves open. I understand there's cases that say otherwise, but I think that still leaves open this argument to be made. Going back to the hearing, this is one of the things that's different about this case, and I think perhaps this court should consider it. But they had no chance to raise the First Step Act in district court. And I think that would have come up had that hearing been held. I don't know if Judge Anderson would have entertained it. I don't know if he would have listened to an argument or a motion. But just reading the transcript of the case, I suspect that maybe just from the statements he made in court and the wording of his orders, I think he might have at least listened to that. I think another thing that's different about this case is the finality of the judgment or sentence. And I know there is some case law that is against us on this, but I want you to consider that Bethea, at the time of the First Step Act, he never got out of district court. I understand the cases, Fourth Circuit cases, talking about, well, the First Act doesn't apply to a case on appeal. Bethea had never even gotten that far yet. He was still in district court. The appeal had not even been filed. As we sit here today, Bethea, his direct appeal and his 2255 motion are both still pending. If the court rules against Mr. Bethea in this case, he goes back to district court to conclude his 2255 case. So I just think that that's something that the court should consider. His case never got to appeal at the time of the First Step Act. And that's the gist of our argument. I'll be glad to answer any questions.
Well, my question to you, Mr. McKenzie, is the appeal waiver valid? And if not, why? I don't see anything in the record that creates invalidity of that appeal waiver.
The appeal waiver is valid, but there are exceptions to an appeal waiver. What we're saying is that, at the time of the resentencing, the vacator of the order and the resentencing, the law had changed. And the First Step Act should have applied at that point. And therefore, the sentence that he got exceeded what was allowed by law.
Right, in this case, what you're saying that the appeal waiver and applying, given a sentence that's consistent with law, are not inconsistent here, they're compatible. Because he still pleads guilty, correct?
I'm sorry, I didn't hear that, Your Honor.
I'm saying enforcement of the waiver, at this point, it really doesn't matter because his sentence was vacated, and so he had to be sentenced again. Right?
Yes, sir, Your Honor.
Right. So he's not asking to mount that waiver. All he's saying he wants to be sentenced according to what the law was at the time of the sentencing, which 401 had amended 841. So that even if his waiver was still there, he's trying to get the legal sentence. I think that's what his claim is, correct?
Yes, Your Honor. And even if there is a valid waiver of appeal, it's well established that doesn't mean that the judge can just do whatever he wants. He doesn't submit himself to the whim of the district court judge. He still has to be sentenced pursuant to law.
Right.
Thank you, Your Honor.
All right. Mr. Hall?
DeHall, like down the hall and to the left.
All right, Mr. DeHall.
All right, good morning, Your Honors. Chief Judge Gregory, may it please the court. Andrew DeHall here on behalf of the United States. I'd like to begin where the other argument left off with, which is with the appeal waiver. As my friend on the other side has said, there isn't a validity problem here. Instead, he's relying on the principle enunciated in Johnson and other cases that an illegal sentence, one that exceeds the statutory maximum, creates an exception to an otherwise valid appellate waiver. We don't think that the the sentence here, certainly the one originally imposed and then just mechanically reimposed, violates either the original law or the amended one. Under the First Step Act, the statutory maximum remains a life max. I noticed that Mr. McKenzie talked about not getting a chance to raise this issue below. We would just reiterate, as we did in our brief, that Mr. Bethea is a very a good pro se litigant. He's had very detailed filings, and one of those filings was an amended 2255 petition that he filed back in April of 2019, several months after the First Step Act became effective. He could have raised it there, and as far as not getting a hearing on it, I think the hearing in scope was to be confined to whether there was ineffective assistance counsel on the appellate issue. So I'm not sure that even if Judge Anderson had found plea counsel, Mr. Delgado, ineffective, that it would have necessarily followed that a resentencing would have happened, because really what Judge Anderson did was give Mr. Bethea the common and logical remedy for failure to appeal, which this court in Haddon and other cases has said does not entitle someone to a new resentencing, and it constitutes a correction of a sentence rather than a resentencing.
So, Mr. DeHall, if you could spend a little more time on this issue, in terms of whether it sounds like there's no issue about the waiver is effective. The issue is whether the sentence, is in violation of the law, is illegal in effect. And it seems like the argument is, well, at the time of the second sentence, that it was, that to sentence him as he did was to sentence him in a way that was contrary to the law. So help us with that issue. Do we not look at the second sentence? And if so, why? And if we look at the second sentence, how is it in compliance with the law?
Thank you, Judge Quattlebaum. To answer those, hopefully in order, I think context is important here, because there are cases out there, I'm sure your honors are familiar with them, that talk about whether this act applies after a sentence has been vacated for a, quote, plenary resentencing on appeal. And to the extent that the panel finds those opinions informative, this is a different type of vacator. This is one not done because of a defect in the sentence or the conviction, which is the whole premise of really, quote, wiping the slate clean for a plenary resentencing. This is something done mechanically in order to restart the clock on the direct appeal time. And so really, even if Judge Anderson had found Mr. Delgado was ineffective, which he didn't, I mean, this was something done as a quote expedient. I think that it's not quite the right focal point to look at the second reimposed identical sentence, just because the nature of it is not tied to a court found defect at all. Now, to your second question, I'd say even if you disagree with me on that, I think it's still not contrary to law, because the plain language of the act has a historical focus of asking whether a sentence had been imposed as of December 21st, 2018. And the answer here plainly is yes.
But that's substantively right. That's not about the waiver. Is that that second argument doesn't have anything to do with the waiver, or maybe it does? Or is that your argument why it's not illegal? I see. I think I understand what you're saying.
Right, Your Honor. I have bled into the merits there. Yes, sir. Chief Judge Gregory, I think you had a question?
No, you're saying that under the new law, we can sentence it to life, a life sentence without possibility of a parole under the new law?
My reading of the amended 841 is that that life is the statutory max on that.
Without parole? Because that's the sentence he gave him.
It did give him mandatory life. That is correct, Your Honor.
Mandatory without the possibility of release.
That's correct.
That's not consistent with the law now.
Well, it would not, see, that kind of puts the cart before the horse, Your Honor.
I'm not what cart am I putting before a horse? I'm asking you a direct question right in the horse's mouth. The question is this: is that permitted under the law now, as amended by 401?
If Mr. Bethea it qualifies under the act, then no, that would not be permitted.
Okay.
Right. And I'm sorry, when I use that term phrase, I mean that to get there, you're kind of looking at the merits in order to decide whether the waiver applies in the first place. That was what I meant by that. And I apologize for being unclear.
But it sounds like what you're saying, as I understand it, is the reason we don't look, your argument is that because of the nature of this the way Judge Anderson vacated the judgment in order to start the appeal time again, that we don't look at whether the sentence complied with the law. Sounds like you're saying the nature of this proceeding is why we don't do that. Is that what I'm understanding?
Yes, Your Honor. That's what I'm saying.
Okay.
You said because the way that the district court did this, that makes it different. The fact that he didn't give a hearing at all and just canceled it and imposed that makes the difference. That deprives us from looking at what a legal sentence would have been after vacature. Is that what your argument is? I didn't hear you make that argument. But is that your argument? Because the way it was done here, that after the vacature, that you don't have to comply with a legal sentence?
My argument, Your Honor, is that his sentence on reimposition was legal.
You just told me that it's not consistent with the new law. You
No,
back
Your
in
Honor.
that circle again?
I apologize, Your Honor.
I know. I think you were trying to adopt what Judge Qualibam said was your argument, but I didn't think you made that argument because it can't be. Basically, the district court speaks by its orders and papers. An order was no hearing, basically, and then he imposed the same sentence, life without the possibility of release. And to say that's not the nature of that changes the law. And the obligation of the law after vacature still requires, the law is a stubborn fact. It just doesn't go away. You got to comply with the law. Go ahead.
Thank you, Your Honor. And I would argue that Judge Anderson did comply with the law because this gets into the merits of that the act does not apply to or did not apply.
I wish you would stop giving the judge's name. It's the district court. I think that it's about the district court. We're talking about it's not the district judge. It's the court. So
yes,
the court did not get what right? What did you say? He got it right. He sentenced, but you said that if that sentence was not consistent. You just said that, and we don't know what the judge would have done at that hearing, but we do know what happened, that he was sentenced to the same sentence. And that's not consistent with the law now.
Your Honor, we maintain the position that it was consistent with the law now because the act does not apply to Mr. Bethea on any type of resentencing or reimposition of judgment because one was already entered as of December 21st, 2018.
But that's gone,
Mr.
though. Isn't that gone? That's what a vacature is. It doesn't exist anymore. You have to be focused on, because we're looking at this retroactively. It's like if someone was sentenced 3 times and all 3 were set aside and vacated, and the last one, you can ignore the last one because the ones that were vacated a year ago, that's a sentence. You have to look at what present time. That's what vacate means. It's dissolved. It doesn't exist. So a sentence has to be based upon the sentence that we're looking at, whether or not that sentence would meet the new guidelines under the first step. That turns temporal adjudication on its head.
Mr. DeHall, let me ask you 2 questions. One, there was no plenary resentencing in this case, was there?
Correct, there was not.
And if we were to agree with the defendant on remand, what happens? And well, before you answer that, everybody's been talking about parole. There is no parole in the federal system. Am I right about that?
That's my understanding, Your Honor.
So if we were to vacate this sentence, send it back, would there be a plenary resentencing or what?
Well, I think the most immediate thing that would happen is the district court would resume the 2255 proceedings that is left in abeyance and hasn't concluded yet. So at that point, it would then rule on the other issues that are still out there. And if it were to, it could then either find that there was some sort of ineffective assistance of counsel requiring relief or not. I don't believe remanding at this point would necessarily result, unless the court were inclined to have that sort of mandate, would lead directly to a plenary resentencing. Because there, again, this is not a case where any sort of defect in his sentence or his conviction has been established.
You don't think that would be just, that the court would be clearly, we know that the range is now 25 to life, and they don't think that's appropriate? And see, if the court, the indication that there was no option other than to give life without release? Is that the government's argument in these cases, of these draconian sentences? I'm not talking about this case, and just these long sentences that now we know first step was meant to correct some of these things. And that's why there's a change. And you're saying that's not appropriate for the court to be informed that the range is 25 to life, but not mandatory life. And I know that's old now, but when you say without release, there are other things like the geriatric provisions and those things like that. Well, without release, if it's without release, you may not be eligible for those in terms of the things like that. So it has some implications, notwithstanding that there's no parole for anybody. But life with no possibility of release has some implications, I would think. You don't think that that's just in the sense that should be sentenced knowing that the range is 25 to life and not a mandatory life? I'm just asking you, is that the government, that's the United States government in a case like this? How was that just?
Your Honor, I appreciate that this gets into some line drawing questions that have been tough to wrestle with. And this court in Jordan and the Seventh Circuit in Pearson and others have acknowledged that Congress drew a line, and it might not be always one that everyone would follow or draw it the same way. But we're here to have that line enforced.
I don't think you established any line at all today. Instead, if anything has been enforced, is that it really does apply. The first step does. This is not a case where I'm saying justice requires to step over a line that's clearly demarcated. I'm saying, why would you step over when we know that it does apply?
Well, Your Honor, we're not saying that it. I'll start again. We think the line is in the statute at section 401C, and the line is drawn at whether a sentence had been imposed as of that date.
And you think it doesn't matter the fact that it was vacated, has nothing to do with it?
We think that the text of the statute does not take that into consideration, but Your Honor, even if it does, say, for example, you were agreeing with the majority in the Seventh Circuit's decision, Uriarte. Their decision was that vacator would apply in the case for plenary resentencing, as long as that took place before December 21st, 2018. So our position is that even if you agree with their analysis there, and we agree with the dissent's analysis in that case, but even if you agree with the majority analysis there, we have a different type of vacator here than the one that they were relying on. And second, even they didn't go so far as to say that a vacator that took place months after the First Step Act became effective would trigger the amendments. In fact, in footnote 3 of their opinion, they suggest that it would not.
Are these facts in the same circumstance as these facts here? It's not the same facts. Plus, first of all, it's not controlling anyway.
Agreed. The facts are slightly different in that case, there was an error found in Mr. Uriarte's sentence on direct appeal, and they had there was a vacator for resentencing there.
So they had a hearing there, didn't you?
Yes, Your Honor. On remand, there was a hearing.
Right. You don't have a hearing here.
Correct. And I think that does distinguish us from that case, because
that makes the vacator even more plenary here because it's just gone.
I think it's an interesting mechanism that we're dealing with here. The summary vacator and 20 minutes later the same substantively same J and C is entered in order to start the clock again. That's why I think I agree with then Judge Barrett's dissent to say that tying it to a nature of a vacator or getting into what kind of vacator is involved is not really consistent with what the Act directs, and creates some problems with trying to parse what counts and what doesn't. But I do think that to the extent we're wondering why Judge Anderson, I'm sorry, Your Honor, the district court did that, I think he was given no reason to think that any sort of relief for ineffective assistance.
Are you speaking for the district court? Can you do that?
No.
I didn't think so. It's not in the record, is it?
I'm sorry, Your Honor. All I was saying is that
you're speculating about something.
Well, no, Your Honor. All I'm saying is that he was given no reason to think that Mr. Bethea wanted any other type of relief for ineffective assistance on the appellate issue than the standard type that this court has approved and that district courts provide. That's all I was saying.
Was there a hearing for given an opportunity to do that, to say what he may or may not want?
There was no hearing in this 2255 proceeding, Your Honor. Correct. I see I'm about out of time. I'm happy to answer any other questions that the court may have.
Thank you.
Thank you, Your Honors.
Ms. McKenzie, you have some time reserved.
Can you hear me now?
Yeah, it's off. You're unmuted.
Sorry about that. The only other thing I have to add is that if Bethea is sentenced under the First Step Act, he cannot be sentenced with an 851 enhancement. His prior convictions do not qualify for an 851 enhancement at all. He is not, theoretically, he could still get a life sentence, but what would happen is he's going to be sentenced by the guidelines, most likely, which would mean a sentence of 12 to 15 years, just to show the significance of what's going on here. And that's all I really have to add. I'll be glad to answer any questions.
All right. Thank you, counsel. I note, Mr. McKenzie, that you're court appointed, and I want you to give a special thanks on behalf of the court, because we rely upon lawyers like yourself to take these assignments in these very important cases, and we really appreciate that. Mr. DeHall, obviously we recognize your able representation of the United States here today as well. We can't come down and shake your hand, but please know that we're very pleased and thankful that your arguments to help us on these cases, and we hope that you will be safe and stay well. Thank you, counsel.
Thank you, Your Honor.
Judge Gregory, can we take a short break?
Absolutely. But ask the clerk to have a short
Thank you, Your Honor. Good morning, Judge Gregory, Judge Floyd, Judge Quattlebaum. May it please the court, my name is Hannah Rogers Metcalf, and I have the privilege to be here today on behalf of the appellant Precious Freeman. I also have the honor to be here today arguing against my dear friend, Mr. Bill Watkins, and I appreciate the court accommodating the lawyers and conducting this argument over Zoom in light of the circumstances. The court has asked me to brief and argue two issues today. The first of those is whether or not Ms. Freeman's 210-month sentence was substantively reasonable. The second issue is was whether Ms. Freeman's retained counsel was ineffective at sentencing. I'll address those issues in that order unless the court would request that I do address them in a different order. Turning first to the question of substantive reasonableness of Ms. Freeman's sentence. Ms. Freeman contends that the district court abused its discretion when it sentenced Freeman to 210 months, and that the sentence was not substantively reasonable because it created unwarranted disparities between Freeman and similarly situated opioid defendants across the nation and within this circuit. It's important to note that the standard of review for substantive reasonableness is an abuse of discretion standard. But this standard is not a rubber stamp. As Judge Gregory, you noted in your concurrence in U.S. v. Evans, this is a meaningful review, echoing what Justice Alito said in his dissent in Gall when he said, the major theme of Booker as well as Reader was that the post-Booker sentencing regime would still promote the Sentencing Reform Act's goal of reducing sentencing disparities. The goal of the court in conducting appellate review is still to make sure that the sentence is reasonable and that there are not excessive disparities, and that the appellate review should iron out sentencing differences. That is
Ms.
exactly.
Metcalf, let me ask you two questions together. One, was the trial judge responsible for raising this issue sui sponte, and is there some obligation on a district court to do any research on this issue of similarly situated defendants before sentencing?
Your Honor, that is a excellent question, and I think it weaves into the second issue. And I'm going to say, Your Honor, I'm not sure here. This unwarranted sentencing disparity at issue in this case was not readily apparent. This was a single defendant. It was not a multi-defendant conspiracy. And there's not a great deal of data within the District of South Carolina that would make this unwarranted disparity readily apparent. I would contend that a trial judge should maintain knowledge of current sentencing trends and standards. However, in the district court's defense in this case, the disparity is not readily apparent. It was only upon, and Your Honor, I did file an Andrews brief initially and was directed to address this issue by the court. But it was only upon reviewing detailed sentencing commission data, and then I provided the graphs for the court, did it become readily apparent to me that Ms. Freeman's sentence was, in fact, although a guideline sentence, a significant outlier from current sentencing trends for opioid defendants. Yes, Judge Quattlebaum.
Ms. Metcalf, as I read the graphs and read your briefs, it looks like the argument is that if you look nationwide based on drug weight, there's an outlier. Is it correct that that does not take into account criminal history and offense level issues that may distinguish defendant sentences?
No, Your Honor, that is not correct. The Sentencing Commission data allows, and this is what I tried to present when I presented this visually with the graphs, it does allow to control for both criminal history, or for criminal history, drug weight, and offense level. So regardless, we can pinpoint in Ms. Freeman's sentence as compared to similarly situated defendants across relevant criminal history scores, as well as offense levels, which I tried to do in presenting that data. So she was a criminal history category 2, and I provide comparators across criminal history category 1, 2, and 3. I chose all 3, Your Honor, in presenting the data because there is a paucity of people sentenced with this drug weight and those criminal histories, but it does allow you to control for all of those factors and to include or exclude weapons enhancements. So in this case, there was no weapon involved, so weapons enhancements were not included. But what the data shows, Your Honor, is that across all criminal history categories and all offense levels and a broad range of drug weight, Ms. Freeman's sentence is an outlier. It is an outlier whether I include criminal history categories 2 or all criminal history categories, including the worst offenders with extensive prior criminal histories. And it is an outlier even with the most prolific opioid defendants with significant drug weights. And Your Honor, I will note for the record that the government appears to concede the fact that her sentence is an outlier when compared against the evidence provided by the U.S. Sentencing Commission. They do not appear to dispute that in their brief. The question really then becomes whether or not the sentence is substantively reasonable in light of this uncontroverted disparity. And I think Judge Gregory's concurrence in the Evans opinion provides the guidance in how this court should examine it in this case. In Evans, Judge Motz, in the opinion for the court, stated that indeed a district court may not even presume that a guideline range is reasonable. The fact that it is a guideline range creates the presumption, but that presumption is not a guarantee, Your Honor. And this court, like the Sentencing Commission, is charged by Congress to iron out those disparities. So in this case, it is a unique situation where the guideline sentence itself fails to properly reflect the 3553A considerations. The district court did a good job of going through a number of the 3553A factors. At JA 136, the district court discusses the nature and circumstance of the offense and the history and characteristics of Ms. Freeman. At 138, he discussed the need for the sentence to reflect the seriousness of the offense. He goes through 5 of the factors. And perhaps because Ms. Freeman is a single defendant in this case, it's not a multi-defendant conspiracy, it's not a large case involving a significant number of defendants, nor is it tied to another indictment. The district court does not address unwarranted sentencing disparities. Now, as we address in the second half of our argument, this may be in fact due to the ineffective assistance provided by Ms. Freeman's counsel, who did not raise the issue with regard to the length of her sentence in his sentencing memorandum or in his arguments to the court at sentencing. I would point the court to Justice Alito's dissent in Gall, where he cites U.S. v. Taylor, and he says, appellate review for abuse of discretion is not an empty formality. And when the trial court is required by statute to take specific factors into account in making a discretionary decision, the trial court must be reversed if it ignored or slighted a factor that Congress has deemed important. It is clear that Congress has deemed unwarranted sentencing disparities to be important, as Judge Gregory really hones in on in his concurrence in Evans. And for whatever reason, the district court slighted this issue of unwarranted sentencing disparities when it came to Ms. Freeman's sentence as it relates to similarly situated opioid defendants, both nationwide and within the Fourth Circuit. If there are no further questions with regard to this issue, I'm happy to turn to the second issue regarding the ineffective assistance provided by Ms. Freeman's counsel.
Ms. Metcalf, I have one question. In establishing substantial discrepancy, what kind of ratio would be enough? 1.5 times the average or 2 times the average? What do you think?
Your Honor, I don't think Ms. Freeman is asking the court to adopt a bright line test of what ratio would be applied. I would only note that in this case, her sentence of 210 months, the median for similarly situated defendants is 75 months. That's defendants with over 10 million grams of marijuana equivalent opioids. The average is just over 95 months. So her sentence is more than double the average. And I'm not a good mathematician, but 75 is a whole lot less than 210, Your Honor. And so while we're not asking the court to establish a bright line test, I will say that the U.S. Sentencing Commission data, when plotted using a line, reveals that the more appropriate sentence would have been a range of 75 to 150 months. Turning to the issue of ineffective assistance of counsel, if I may, Ms. Freeman was represented by appointed federal defender up until just before the sentence, and then she had retained counsel. This motion, or the brief and argument relates only to retained counsel, Your Honors. The Strickland test makes it clear that there's a performance prong and then there's a prejudice prong. And with regard to the performance prong, Ms. Freeman contends that her retained counsel's performance was deficient with respect to the prevailing professional norms and duties. He had a duty to investigate and research her case in a manner that was sufficient to support informed legal judgments. That's from this court's Carthorne decision. It is clear that retained counsel's ignorance of the law that was fundamental to her case, combined with his failure to perform basic research, resulted in unreasonable performance. And I point the court to JA 108, where the retained counsel at sentencing said, Your Honor, when asked about withdrawing the objections, said, Your Honor, none of these objections reduce the number that is relevant to this court. And with that in mind, we don't wish to dwell on those. The district court seemed somewhat shocked by this statement and somewhat of a comical, because he says, well, hold on, let me ask my question again. He asked it repeatedly, are you sure you want to withdraw all of these objections? And he says, retained counsel says, these objections are not going to change in essence what the charges are. And we believe the drug court is more pertinent than objections over what might be considered minimal, even if found to be appropriate. That's at JA 107. As the government pointed out in their brief, these are not minimal changes. Yes, Judge Quattlebaum.
Ms. Metcalf, your brief outlines some issues on ineffective assistance of counsel, and my question is really not to quarrel or even talk about that. It's to talk about the appropriateness of us looking at that right now versus perhaps as a collateral attack. I'm not sure what the defense would be. Maybe there is none, but we don't even have anything from counsel to provide an explanation. I know we have the possibility of doing that, but is it really advisable for us to do that without even hearing what the counsel's position would be?
Your Honor, I do agree that it is more generally, ineffective assistance of counsel is more generally considered on indirect appeal and is often more appropriate because of the lack of information contained in the record on appeal. In this case, however, where the ineffective assistance of counsel is obvious on the record, the court may consider it, and it is appropriate on direct appeal. Although unusual, there are not a lot of cases where ineffective assistance of counsel is considered on a direct appeal. Here, it is clear from the record that counsel was not familiar with how objections work within the Fourth Circuit. Counsel did not understand how the bridge court works, did not understand that his client was not eligible for the bridge court, which is as Your Honor is very well aware, it's a very small program. Very few defendants are admitted into the drug court program. She was not eligible, and he gave up valid objections and stated on the record that he felt they didn't matter. It's clear that she was not aware that he was going to drop that, and neither was the government or the court. There were agents sitting in the courtroom ready to address these objections. This demonstrates clearly from the record that he was not prepared, did not do his research, and was ignorant of the law and the rules. And this is further highlighted by his filing a civil motion for reconsideration afterwards, which is not allowed in a criminal case, which the district court appropriately pointed out in its text order response. To sum up, Your Honors, we are requesting that this court reverse the district court and find that it abused its discretion with regard to the 210-month sentence, and find that her counsel was ineffective, and remand this matter for resentencing.
Thank you, Ms. Metcalf. Mr. Watkins?
Good morning, Your Honors. My name is Bill Watkins, and I represent the government in this case. Your Honors, the government is asking you to affirm this sentence as substantively reasonable. If you look at what the district court did in this case based on a total.
You're muted now.
Mr. Watkins?
You're muted.
I've asked. Mr. Watkins, I can call you and invite you for voice so you can continue that way, okay?
Okay, my microphone shows that I'm unmuted.
It's now, it is. It is now. Go ahead, Mr. Watkins. You may proceed.
Good morning, Your Honors. Assuming you didn't hear anything I had to say, I'll introduce myself again. I'm Bill Watkins. I represent the government in this case, and we're asking that you affirm this district court's sentence in this matter on both grounds raised, the reasonableness of the sentence as well as the ineffectiveness claim. First, Your Honors, I believe that what the district court did in this case is absolutely substantively reasonable under a totality of the circumstances analysis. This is not a case where the district court mentions one factor or finds this to be a mine run of cases and relies on the guidelines. No, Your Honor, this is an exhaustive analysis where the district judge goes through how this was an offense that went on for a significant period of time, that this defendant was a major supplier of pills, that this was a serious problem, the opioid epidemic in the District of South Carolina and nationwide. The district court looked at her prior state convictions for similar conduct, took that into account, and noted the state interaction had not changed Ms. Freeman's habits. The district judge listened to arguments about her drug addiction and took that into account when he recommended the RDAP program in the Bureau of Prisons, and noted that this has a devastating effect on society. The district court also mentioned Ms. Freeman's family, her husband, the ages of her children, that he understood that she was going to have to be away from her family for, regrettably, a long time. But that is because of the decisions Ms. Freeman made and her conduct. And he gave her a within guideline sentence, which is presumptively reasonable. Now, Your Honors, I think when Judge Gregory, were you about to question me?
Oh. Well, you're very perceptive. Yes. You said this was all her fault and those things that at 18 years old, she became addicted to opioids because she had a serious spinal injury in the fall. And that put her in a situation of a tailspin of being addicted to opioids. And as Ms. Metcalf said, I think aptly so, our nation has responded differently to these things, unlike it did with the war on drugs that started in the late 60s. Congress appropriated money and all those things, and rightfully so, and they saw that this was treatment. And so we had to look at it in the context of this. But a sentence of 210 months, they face in terms of the average, that kind of sentence, this is not a procedural challenge at this point, it's substantive. And that is not whether things were a calculation of guidelines and non-frivolous arguments and those things procedurally, but we're talking about at the end, it's 210 months with the, I know it's a partly kind of framework. She has, she had a baby during the time, from the time of what the discharge, the baby was born, correct? Her fifth
Yes,
child?
sir. She had
Her fifth child, right? And she was addicted to opioids since she was 18 years old. And you talked about major evidence that significant amount of these pills, she was taking them for herself, correct?
That is what she told the court.
It's undisputed though.
I wouldn't say that, Judge. I would disagree, because the first time she ever raised the issue of addiction is when she learned in the court system there was something called the bridge program, and dealing with the agents in her prior interviews. She never claimed to be an addict. She admitted to what she was doing. She was selling and dealing. But Judge Gregory, sir, I agree with you. Is this a sad situation for this defendant? Absolutely, sir. Is addiction a horrible thing to deal with? Absolutely, sir. But the question is this a reasonable sentence under the totality of the circumstances? And I believe that it is. And Judge, I know Ms. Metcalf has shown us these graphs and things. She's done very good work. She's a great lawyer in this town. But for example, she says that with a criminal history category of 1 to 3, an offense level, and I assume she means a total offense level of at least 30, no weapon enhancement, which we don't have, and a large drug weight. You know, most sentences run between 75 and 150 months there. But what that doesn't take into account, Judge, is we're not at just a level 30. She comes in at a level 36, well above a level 30 or 31. And unfortunately, it was because of decisions she made to abscond, to engage in new criminal conduct, to be arrested, which in itself is a 5-point swing. Had she not done that, Judge, she would have come in at a likely range of 87 to 108, which is what Ms. Metcalf says most folks like Ms. Freeman should get. But most folks aren't engaging in that sort of misconduct and shooting themselves in the foot. And I feel for her on that. I wish she had not done that.
But the problem is, and I know Ms. Metcalf took them seriatim, but they're connected. The ineffective assistance of counsel had a whole lot to do with what eventually became her level, the obstruction of justice and all those things. These arguments weren't even made. There are plenty of arguments to be made, perhaps, maybe, whether or not she should have been had obstruction at all. I mean, she didn't have any place to go, and she went across the lines with her family, and none of those things were made at all. So I know you're saying in a perfect world, if there was effective counsel, then that's where she would be. But when you put those together, you know, and by the way, do you defend the performance prong of Strickland in this case?
Judge, I don't know exactly why counsel did what he did in this case in withdrawing the objections, as it was pointed out, that we don't have an affidavit, there's been no hearing in the district court. At best, I can speculate that counsel recognized that he did not have great objections, they were not meritorious, that he did not want the government to call 2 solid case agents to talk about aggravating conduct, and that he would try to throw himself on the court's mercy, get her in the bridge program or a lower sentence. I don't think that was a bad decision insofar as I don't think that the objections had much merit. Like, for example, Judge, you mentioned the obstruction of justice. It wasn't that just a hurricane came and she went to Shelby because she was being evicted. She was told to come back to South Carolina, refused to, and then went on the run for 6 months, received new charges for drugs, and was trying to funnel drugs into a state prison. Respectfully, sir, I think under those facts, I can't imagine a district judge in this district not giving her obstruction or taking away her acceptance of responsibility for that sort of conduct. We don't know exactly why counsel did what he did, but to the extent we have to speculate, I see a good and just reason. Ms. Freeman engaged in very bad behavior, and you didn't want, as counsel, case agents testifying, coming in and highlighting aggravating factors. And therefore, he withdrew his objections and tried and made a very compelling argument about her addiction and her family circumstances, and he tried to hang his hat on that. It did not go over with the district judge, and he sentenced her to the low end of the guidelines. Again, we can't get in the district judge's head, but perhaps it did. It was a very good argument and saved her from a high end of 240.
Wow. I appreciate your response. Thank you so much, Mr. Watkins.
Yes, sir. Unless the panel has any further questions for me, I'll rely on our brief, but I'm happy to answer anything else if Judges Quattlebaum or Floyd have anything for me.
Mr. Watkins, I do have one question. I think I recall that you put in the brief that the judge said that he would impose the same sentence over. By that, are you asking us to find no prejudice anytime a trial court makes a blanket statement such as that and impose the same sentence even if it's miscalculated?
No, sir. I'm just simply asking you to follow the law of Savion Matute, that if there's a miscalculated guideline range, but the district court makes clear that even in light of the error, this is the sentence that he thinks proper, and that sentence is substantively reasonable, then there is no reason to send it back, and there's no reason to find any prejudice there. So I'm simply asking that Savion Matute be followed to the extent you see a problem with the guidelines, because this district judge on 2 occasions made it very clear that he would have given the exact same sentence at the sentencing hearing, and then upon a motion to reconsider where trial counsel tried to bring some other points up in the objections that he had decided to withdraw. This district judge, again, went back through 3553A factors. The length of the criminal activity, the seriousness of the conduct, the criminal record, and said he would not change one jot or tittle of the sentence. And I think Savion Matute, we must respect that, and it would not be a good use of resources to send that back for him to impose the same 210-month sentence.
Mr. Watkins, do you think in order to find substantive unreasonableness that the judge has to make a mistake?
I would say he has to make a mistake in his analysis and the totality, Judge Gregory. I mean, I think there is a continuum of reasonable sentences. Had Ms. Freeman come before you 3 gentlemen separately as trial judges, it would be very conceivable she would receive 3 different sentences. And all 3 could be substantively reasonable. Maybe not. We don't know the full circumstances. But I think the error would be in the totality of his analysis, that he had to overlook so much or make a grave mistake for it to be unreasonable. So that would be my view of it, Chief Judge Gregory.
Nothing further?
Yeah, if there's nothing else for me, I will stand on my brief, but happy to answer any other questions.
Ms. Metcalf?
Thank you, Judge Gregory. I'd like to just briefly address a few of the things that were addressed by Mr. Watkins. First, Mr. Watkins repeatedly points to the totality of the circumstances. But as you, Judge Gregory, explained in your concurrence in Evans, the totality of the circumstances, substantive reasonableness calculus demands that the appellate court proceed beyond a formalistic review of whether the district court recited and reviewed the 3553A factors and ensure that the sentence caters to the individual circumstances of the defendant, yet retains a semblance of consistency with similarly situated defendants. And that is what is lacking here. And it may be lacking because Ms. Freeman's retained counsel was ineffective and didn't raise this issue. It may be lacking because the district court was not fully aware of this nationwide trend that is reflected in the data from the Sentencing Commission. This has been an evolving area nationwide with regard to opioid defendants, as Your Honor points out. The current administration has launched significant changes with regard to opioid defendants, as did the previous administration. There is significant civil litigation against the manufacturers of opioids, and there's significant litigation and action at the state level with regard to these defendants. So the nation as a whole, the District of South Carolina, the Fourth Circuit has changed in how they view these defendants, and therefore the sentences have all trended lower, which the data reveals. Specifically with regard to Mr. Watkins' point about the data concerning Ms. Freeman, he stated that this data shows somebody with an offense level 30. In fact, the charts that we've provided, and I point the court to page 27 of my brief, you will see that reflects Fourth Circuit opioid defendants with a criminal history category of 1 to 3, a drug weight of 1 million to 50 million grams, and an offense level of 30 to 60 with no weapon enhancement. And it is clear there that Ms. Freeman's sentence is there, again, an outlier, significantly an outlier. The court, when going through the 5553A factors, did not go through, when it went back and it said I would sentence the same, it did not go back and look at unwarranted sentencing disparities. And if I can address briefly Mr. Watkins' argument that the assumed harmless error standard should apply here, that standard does not apply because the district court did not decide any issues with regard to these objections because counsel withdrew those objections. So that standard says that there has to be knowledge that the district court would have reached the same result even if it had decided the guideline issues the other way. Well, here we don't have the benefit of the district court making a decision because counsel withdrew these valid objections. And these objections are valid. For example, with regard to obstruction, the evidence shows that, or the testimony at sentencing, which is the only evidence in the record with regard to her flight, shows that she was evicted, she was pregnant. She stated on the record that she called her probation officer, said, "I'm going to my parents' house in Shelby," where she was allowed to go. So those are very valid objections, and there's significant case law that says that kind of panicked, instinctive flight does not rise to the level of an obstruction of justice enhancement. But the district court did not decide those guidelines issues, so therefore there cannot be an assumption that that decision was reasonable. There also shouldn't be an assumption that the sentence is reasonable where it was reached due to the ineffectiveness of counsel. Finally, with regard to ineffective assistance, what the record shows is that the retained counsel hung his hat on drug court, which Mr. Watkins points out, but she was never eligible for a drug court. So to abandon non-frivolous objections based on an argument that she should be admitted to a drug court program to which she was ineligible for admittance is on its face evidence of ineffective assistance of counsel. And then to combine that with his failure to raise the fact that this 210-month sentence was significantly greater than the sentences received by other defendants we contend should compel this court to reverse the district court and remand for resentencing in light of all of the 3553A factors, including the disparity between her sentence and other similarly situated defendants. If there's nothing further, I'll yield the remainder of my time.
Thank you, counsel. Ms. Metcalf, I note that you're court appointed, and I give a special thanks to you, lawyers like yourself, and taking these cases, helping us in very thorough work on cases, very helpful and very difficult cases. I really appreciate on behalf of the court. Mr. Watkins, of course, we recognize your able representation of the United States. Counsel, we can't come down and greet you in our normal fashion. We missed that. It's a very important part. I think it's a great tradition, but we can't do that. But please know that nonetheless, we appreciate what you do and your help and very ably presenting before us. Wish that you would be safe and stay well. Thank you, counsel.
Thank you, Your Honor.
Thank you, judges.
All right.
Thank you.
Good morning, Judge Gregory, Judge Floyd, and Judge Quattlebaum. May it please the court. I am Jay Hurst, and I'm here on behalf of defendant appellant Christian Allmendinger, who is serving 540-month sentence for mail frauds and conspiracy to commit mail frauds that were convicted by a jury. This matter involves a resentencing hearing, however, that turned out exactly like the original sentencing nearly a decade before, despite 3 fewer convictions and despite the district court recognizing that a different defendant was before the court. With a hat tip to the guidelines and weighing that the offender's prior punishment and positive changes were not relevant enough to overcome the original decision, the district court clarified that neither a changed offense nor a changed offender would change the ultimate sentence in this case. This decision turns on a couple of technical and perhaps hyper-technical legal distinctions, starting with procedural versus substantive reasonableness. This classification is most important here because it affects the standard of review, whether there is more of a legal analysis in the de novo sense as to failure to consider, or a more deferential abuse of discretion standard used more toward factual considerations. In this case, it's a significant overlap between the two because the court went on record as saying it did consider the post-offense rehabilitation of Mr. Allmendinger, but at the same time said that it did not consider that rehabilitation to merit mitigation against the original decision. So with the law of the circuit being basically unclear on this point, there's no clear delineation between substantive and procedural reasonableness in this case. We would ask, therefore, that the standard applied be looking to the legal standard of whether the district court hits post-offense rehabilitation and considered it appropriately. The how of how a sentence is rendered is the procedural side. Whether after the procedure is correct, the court has justified that final sentence, that's substantive. But to get to there, you first have to consider whether the district court in this case appropriately followed an appropriate procedure in considering post-offense rehabilitation. Now, all courts have occasionally had trouble trying to categorize this reasonableness. There's not going to be a bright line test or distinction that the court could pull out of this case. In fact, I don't think, just because it is more in line with a Venn diagram than it is 2 blocks side by side. There is an approach where you look at what the district court said and you look at the sentencing hearing transcript, and there is an analysis that, yes, I do understand that this is a different person before the court. So the judge does recognize to some degree that there's a change. The problem is the judge in the sentencing court did not recognize that that change was statutorily required to be weighed up against and to have some mitigation value. That's why in our sentencing papers at the trial court level, and this is at JA 164, I believe, we discussed North Carolina v. Pierce and the legal concept of vindictive sentencing. Now, we're not saying
so,
that,
Mr. Hurst, if I could stop you there, I'm trying to make sure I understand what your argument requires the district court to do. The district court, as you know, acknowledged that he had, that spending time in prison had changed him, and looked at all the factors and decided to impose the same sentence. You just said something that I want to make sure I understand. It sounds like you say that if that fact is recognized, there must be some mitigation. So are you saying it is that the district court would be obligated to reduce the sentence if there's an acknowledgement that he has changed some? It sounds like you're saying that acknowledgement required a reduction. And if that's your position, I just want to make sure I understand it.
in this particular case with these particular facts, I do believe that is what the district court would have to wind up doing to avoid rising to a quote unquote vindictive sentence per North Carolina v. Pierce. And it's not that the vindictiveness is in our normal usage. You know, there wasn't any meanness or mean-spiritedness. But the idea is that with a different set of offenses, there weren't even the same number of offenses, criminal conduct was different, and the offender himself was different from the person who appeared, and in fact had set himself up to flee before he came back to court 10 years ago. That's not the same person there now. So in a balancing test, those factors did not exist before, they do now, and it would be impossible to consider them under the statute without them having some kind of impact.
Mr. Hertz, to follow up on Judge Quattlebaum's question, the Supreme Court in Pepper said the court may consider post-sentencing rehabilitation. It seems to me all he has to do is to consider it. He doesn't have to accept it. Would you agree with that?
I would agree that the district court would be required to consider it. I think that's probably poorly phrased by the Supreme Court, quite frankly, the risk of seeming arrogant. But the idea that an offender can change, but a district court need only maybe consider it at a future sentencing. That doesn't comport with the statute of 3553A1, which says that the offender at that sentencing must be considered. So to the extent that we're talking about post-offense rehabilitation having fundamentally altered one of the statutory sentencing considerations, that's what I'm getting at. As far as a judge looking and saying, okay, well, he taught GED courses and he also helped in the library, that kind of rehabilitative efforts, sure, the court can look at that and say that's fine, but that's not enough. But where there's a fundamental change in the person before the court, that becomes a statutory sentencing factor that the judge has to consider.
And what do you suggest is the fundamental change here?
The change in the defendant, in Mr. Allmendinger. Sorry.
Go ahead. And how is that proven in the record?
That is
fundamental change. Go ahead.
Well, it's acknowledged by the court after the sentencing discussions where we discussed that he was originally assigned because of sentence length into a U.S. penitentiary, which is high security. And then while he was in the facilities, he got into GED tutoring. He worked his way down to where he is now at a medium security facility. Through all this process, when he allocated and when he spoke to the sentencing court itself said that this was clearly not the same individual who had
collected his belongings and was getting ready to run before the first sentence. That was clearly a different person before the court. So besides the evidence,
you think that's evidence that it's fundamental change?
That there's fundamental change in the humility of the person? Yes, I do believe that the district court recognized that as fundamental change in the person.
Well, yeah, I think, okay, never mind, go ahead.
Certainly if I'm unclear, I'll try to fix that, my apologies. Really what it boils down to is how much discretion does a court have, a sentencing court at the district court level? The answer is almost limitless if they explain correctly, as was pointed out. However, where they explain correctly that they chose not to include a particular statutory factor, in this case, the post-sentencing rehabilitation that changed the offender that the district court acknowledged was a changed offender, that becomes a procedural flaw in how the calculus is done. So that's the position we're on, and that feeds us into what I know is really a throwaway argument because of the Supreme Court holding. But the idea of the sentencing court finding these facts despite jury convictions by a preponderance of evidence instead of beyond a reasonable doubt. So there's an issue there that has to be addressed by the Supreme Court if it's ever to be addressed. But that issue also feeds in and illustrates how the sentencing didn't change no matter what the jury did, and it calls into question not just the jury's work and the value of the jury, whether it's a bulwark, but whether the original sentencing and appellate counsel actually had made any mistakes at all. This is a resentencing from a 2255, in fact, where the issue of money laundering convictions was not raised on appeal, with the idea that the same sentence would be rendered in the trial court whether there were money laundering convictions or not. The ineffective assistance of counsel was found. It was sent back to the district court. 3 money laundering charges disappeared, and then nothing more changed. So from that, we're left with the opinion that, or with the apparent observation that juries have only a limited relevance in our system. And I'm not sure as a policy matter, let alone from a Sixth Amendment standpoint, that's appropriate. Unless the panel has any questions for me, I would reserve the balance of my time and leave the government to speak.
Thank you, Mr. Hurst. Ms. Aber?
Good morning, Your Honors, and may it please the court. Federal sentencing law, as this court knows, is almost entirely permissive, and even a cursory examination of the sentencing transcript shows that the district court fully considered and assessed the defendant's arguments before rejecting them. The district court's decision to reimpose the same 45-year sentence on remand should be affirmed. And I'll begin with where I believe Mr. Hurst was going towards the end of his argument. I understood him to be saying, in response to Your Honor's question, that a court must consider evidence of post-sentencing rehabilitation in fashioning a sentence under 18 U.S.C. 3553A. And I agree with Judge Floyd that Pepper authorizes a court the opportunity to consider it. A district court may consider it. But here, even if we accept Mr. Hurst's line of argument that a court must consider it, we have evidence before us that the district court did in fact consider the limited evidence of Mr. Allmendinger's post-sentencing rehabilitation. And that limited evidence was counsel's proffer that Mr. Allmendinger had moved from a penitentiary to a medium facility within the Bureau of Prisons. He also represented that Mr. Allmendinger had participated in GED tutoring. And third, Mr. Hurst represented that the defendant was in fact a changed man as a result of his current time in prison. And none of that is one would hope that Mr. Allmendinger was a different man after spending 7 odd years in prison. But the court did consider these factors on JA 223 and 226. The court says, I'm considering it and I'm rejecting it. And a district court is authorized to do so under Gall. A district court may apply whatever weight it wishes to 3553A factors. In this instance, the court was very clear that Mr. Allmendinger's conduct was abhorrent, and it weighed very heavily the seriousness of the offense. As this court noted in 2013, his crimes, his mail fraud conspiracy, caused an unthinkable scope of financial ruin to hundreds of people. Victim impact testimony taken live at the first sentencing, and then provided in 2 inches of victim impact statements before the district court upon resentencing, established the crushing effect that this conspiracy had on many people's lives. That, in addition to what Mr. Hurst has alluded to, Mr. Allmendinger's failure to accept responsibility, his efforts to squirrel away cash, to flee before trial, all of that was simply outweighed by the district court, or it outweighed in the district court's mind any post-sentencing rehabilitation evidence that Mr. Allmendinger presented. And that is the court's prerogative, and that is lawful under the law. For that reason, Your Honors, I will say that the evidence before this court is that Mr. Allmendinger's sentence was procedurally and substantively reasonable. As I indicated, the court engaged in banter extensively with Mr. Hurst about the factors it was considering, what Mr. Hurst was arguing, whether it was a departure, whether it was a variance, and went on to really provide a very thorough explanation as to why it was reimposing the same sentence. A below guideline sentence, I'll add. In this instance, Mr. Allmendinger's revised advisory guideline range was reduced from 1,500 months to 780 months. It's still an enormous sentence, and the court imposed a sentence below the 780 months to a sentence of 45 years. And that is a procedurally reasonable sentence. As to substantively reasonableness, the substantive reasonableness of his sentence, Your Honors, I understood Mr. Hurst in his brief to be arguing that the sentence was substantively unreasonable due to its length. That was discounted by another panel of this court in 2013, that a 45-year sentence for a crime of this nature is not outside of the realm of possibility for an offense like this, with an offender like this, under all of the 3553A factors. So unless the court has some questions for me, I'm happy to rest on my brief as well.
I have a question. There's a reference, I believe I'm correct about this, that the court found, I think the reference to that the victims were vulnerable. You remember that?
Yes, sir, Your Honor.
What was the basis of finding that they were vulnerable?
At the initial sentencing, there was live testimony, and much of it was supported in the victim impact statements. Well, let me start there and then I'll back up. The victims who testified, many of whom were elderly. They were near retirement age, and they were on their way to retirement, and A&O had essentially decimated their retirement accounts. Also during trial, the court heard evidence that Allmendinger and his co-conspirators deliberately marketed their product as suitable for retirement funds. And at that time in the market, the returns were not great. And so as a practical matter, the large part of the victims of A&O were folks on the cusp of retirement who at the last minute put their funds or their teenage kids' college funds into A&O and then lost it all. And so there's never been any challenge to the vulnerability of these victims due to age and in some instances disability. But that also added, Your Honor, to the seriousness of the offense, to the terrible situation before the court at the time it imposed sentence. So with that, I rest on my brief and I ask that you please affirm the conviction and sentence of Mr. Allmendinger again. Thank you.
Thank you. Mr. Hurst, you have some time reserved.
Yes, I would add just a few things. The first one would be that under 18 U.S. Code 3661, there is a mandate that the sentencing courts consider evidence put before them that is of sufficient reliability and trustworthiness. So to the extent that courts are being distinguished between what they may consider and must consider, if there's a non-frivolous argument, courts must consider that, the trial court. To the extent that we put on evidence that the court itself found was a change of character, Closing out the hearing, the trial court said that I do accept he is somewhat remorseful now. This is at JA 232. That he's more remorseful now than he was 8 years ago. He's certainly not the same person who structured a plan and packed his car, raided his wife's account, and was ready to flee. So the trial court itself distinguished this is a different human being than the one that was before the court the first time.
Mr. Hurst,
yes.
Did the court address your argument that early release would perhaps facilitate restitution?
To my knowledge, we did not go into that because the holding was that the punishment, deterrence, and incapacitation factors were the outweighing facters.
I thought you argued that. That was one of your arguments. Am I wrong?
Yes, that was in the sentencing papers, and it's certainly something I raised at the hearing, if I recall correctly, but it's not something we discussed at length.
Also, in other words, so you concede that the court didn't have to consider that?
No, I won't concede that it, I would say, in fact, the court did have to consider that to the extent that I had missed that issue to this point. That's on me, honestly.
Oh, I asked you about it, and you said, well, we didn't push that, but that's not frivolous, is it?
That's not frivolous.
It's all about, this case is about people, as counsel just said, very aptly, this is about people losing money. So you put forth one that says, wait a minute, if you want me to help get their money back, getting out earlier might help do that. That's not frivolous. I mean, so otherwise, you don't think that the court needed to address that?
Well, it's one of two answers to that, and I hate to put myself in the mind of the district court, but.
No, I'm not talking about the district court. I'm talking about what the district court, whether or not in terms of that. In other words, you didn't emphasize it. You think you didn't bring it. You didn't punctuate it. I'm just understanding. You just put it in there and didn't further it. Is that right?
I raised it to my recollection at the hearing itself. I didn't press very, very hard because we were working on the other issues about, the post-offense rehabilitation. And, as the sentencing hearing progressed, obviously, at some point it became clear we were losing ground on that argument. But I do think it's an argument, a non-frivolous argument that wasn't fully addressed, even if it might have been mentioned in the terms of other needs for other sentencing purposes. I hope that answered the question. I'm sensing it might not have. If there are no other questions from the bench, I appreciate everyone's time. I do appreciate the effort you put into the reading, and thank you very much. We look forward to a decision.
Thank you, counsel. I note, Mr. Hurst, you also court appointed. We appreciate that on behalf of the court for lawyers like yourself to take these cases to help us with these sometimes very thorny issues, and we appreciate it very much. Ms. Aber obviously note your able representation of the United States as well. Counsel, instead of coming down to greet you, handshakes, we'll have to say we appreciate it so much. We thank you for your argument, your being here, and wish you well and be safe and stay well. Thank you so much. With that, I'll ask the clerk to adjourn the court, I guess, until this afternoon, or recess, I should say.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will be moving